So many questions are asked by one of the young friends, a junior advocate probably. His name is Ravi Mandalia, about judgments, about finding judgments, about resources and sources of judgment. He says, Sir, my name is Ravi Mandalia. My question is how to find judgment. So many books are there. Is it necessary that judgment that we find has to be similar to our present case? How many legal search engines are there? Do we need to read all EBC and AIR books? Thank you, sir. So, Ravi wants to ask something that every junior lawyer would want to know. So, today in this video, I'll be addressing that question, how to find judgments. Now, the first thing you all should bear in mind is that there need not always be a judgment applicable to your case. There may or there may not be. But it's not a rule that every case must have case laws. Not necessary. The point that is involved in your case may not have been previously decided by any court. This is quite possible. And in such situation, a judgment may not be available. But even to know that, even to come to that conclusion, a deep research is needed. So, there is no escape from making a research regarding finding judgments. Now, before you set out for finding judgments, for doing research with regard to case laws, firstly, you must decide which type of law governs your case. And when I say which type of law, I mean whether the codified law governs your case or uncodified law governs your case. What I mean by codified law? I mean whether your case is governed by some act of parliament or some act passed by state legislature, or some rules made by the central government or say state government in exercise of the powers conferred upon the government by the act of parliament or by the act of state legislature. Even such rules take the form of delegated legislation. So that is codified law. Or there could be some government resolution. It's not law, but maybe it still governs your case. It still has binding effect. We can call it kind of codified form of policy. So whether your case is governed, I mean the legal points involved in your case are based upon the codified law or uncodified law. And when I talk of uncodified law, I mean the case laws. Now, when can a situation be governed by an act of parliament or purely by the case laws, or maybe by both, can be known by you by studying the facts of your case and the area of law governing your case. For example, if your case is based upon, say, the negligence of the defendant, and you are filing a suit for damages, and the case is governed not by any codified law, then the basis of your case will be law of torts, which is purely judge-made law, purely the case laws. Right. But if you are filing a case regarding motor accidents, you will find that there is an act of parliament, Motor Vehicles Act. Your case is governed by the act of negligence is involved there also. Basically, that is the law of negligence in a codified format with regard to motor accidents. But that is codified law. So the basis of your case here would be codified law. That means the act of parliament, right? Or say your case is based upon some specific relief. That is again based upon act of parliament, the specific relief act. Or the codified law governing your case could be, say, Consumer Protection Act, or some other law like Contract Act. So whenever your case is governed by codified law, the first thing that you must research is the provisions of the codified law itself. After that comes the question whether the codified provisions, I mean the provisions contained in the acts of legislature, have been given some meaning by the court through interpretative process in their judgments, reported judgments. Then you start looking into the commentaries of that particular act, the commentaries written by eminent authors. And the commentaries would mostly contain not only the comments emanating from the minds of the scholars and authors, but also the interpretation given by the courts through various case laws. So good commentaries become your one of the resources for finding case laws, commentaries of that particular statute. Then there are digests dedicated to certain specific subjects. Digest contains case notes of various case laws. Like there are digests brought out by All India Reporter in AIR manual. So commentaries, digests become the source of research for case laws. And if your case is purely governed by the common law, I mean the judge-made law, the case laws, then also you look into the commentaries and digests dedicated to those subjects. Like for example, if you are searching for case laws under law of torts, you would look into good commentaries of law of torts, which would contain various citations to the case laws deciding that particular point. That becomes your source, and that's how you should approach researching your case. Then comes the turn of softwares. Now these are the days of technological advancement. We are in a technological era. So we have at our fingertips the softwares containing various case laws. When I was a junior, that time we used to search through the physical books. There were piles and piles and piles of books we used to bring on a particular table, and then we used to search through that, page by page, point by point, noting down various citations. But then this generation is so lucky that you have got good quality softwares containing various case laws of various companies available for you at your fingertip. And if you are in a big city like Mumbai or Mumbai, Delhi, even Nagpur, the Bar Association here have created beautiful e-libraries. There are computer terminals everywhere loaded with softwares of various case laws, and all young advocates, young middle level and senior advocates doing their research at the click of the button. So you just insert the search term and press enter, you get entire list of cases containing that particular search term, and then you prune the the list, and note down the relevant case laws. So that is how you approach doing research. First, you determine if your case is governed by some codified law. Then you study that codified law, the legal provisions. Then to check whether the particular legal provision or provisions applicable to your case have been actually interpreted by the superior courts like Supreme Court or High Court in any particular manner, either in your favor or against you. You ascertain whether there is any case law on that point or not. And for finding out whether there are any case laws on that particular point, you look into good commentaries, number one, you look into the digests, then you look into the software. And the fourth resource could be internet, Google. Now there is ChatGPT that is now creating havoc. It is going to take us to the next level. Today it is still in beta stage, but it is going to create a havoc in future. So that is how you approach making research on case laws. But it should not be the other way around. I mean, it should not start with internet and end with the commentary. It should start with the commentary and end with the internet. Many young junior friends make that mistake of starting directly from Google, internet, or maybe some website, famous website, and then coming down up to the commentary. I don't know whether they really look into the commentary or the statute, original statute or not. So it should not be outside in, it should be inside out. You start with the basic provision and then you go on searching the commentary, the digest, the internet, the softwares and the internet. All this research of yours will then lead to actual books containing the judgment. Now, there are various law reports, famous law reports that you all must be knowing. So each citation that you gather leads you to the actual text of the judgment, either in the printed books or in the digital books or in the software itself. You can take a printout of the judgment from the software itself and then study. So that's how you make research of case laws. And that's the answer to your first question, how to find judgments. Now the whole thing doesn't stop here. There is one more important step, and that is that you have to carefully and meticulously read the judgments that you have found and then segregate those which are really applicable to your case from those which are not. You will find so many case laws seemingly containing the point that you want or the point that you think is involved in your case or that you think is decided in your favor. But when you actually look into the case laws, the judgments, you may find that only a few of them are really relevant, others not. Some judgments may be really relevant and may be favorable to you, and some judgments which may be really relevant but may be against you. So you have to notice both types of judgments, not irrelevant, but the relevant ones which are in your favor and which are against you. You of course must be aware of what may come from the opposite party, your opposing side, which judgment they may cite, and which judgment you are going to cite. So that's how you conduct research of judgments. But then that's not all, there is something more. The judgments which are in your favor, you will be definitely using them. But those judgments which are against you, you will have to be creative in finding out ways how to convince the court that this judgment is not really fatal to your case, though it is against you. And that is where comes the technique, the famous technique of distinction. The technique of distinguishing a particular judgment as not applicable to your case for A, B, C reasons. And that takes us to your next question that you asked. You ask whether the judgment that we find has to be similar to our case. The answer is both yes and no. Let me deal with no first. I am saying no in the sense that it need not be a clone of your case. No two cases are clones of each other. They may be similar, but there must be some difference. Always there is. Every case has a different texture of its own. But when I say yes, I mean the facts involved in both the cases. I mean the material facts. Yes, that's the right word. The material facts involved in your case and the cited precedent must be same, should be same. Only then the ratio of that particular case law will be applicable to your case, will govern your case. So you have to learn to find out what are the material facts. There may be difference of opinion between 2-3 persons as to whether a particular fact is material or not. But then you will learn to identify the material facts with your experience. If you are at a very initial stage, you can take guidance from seniors to know whether that particular judgment and the case that you are dealing with contains similar material facts or not. Because a lot turns upon the material facts. As I told you, a case is distinguished on the basis of material facts only. Many times you must have read in various judgments that a particular case law cited before the court was distinguished by the court, saying that the facts involved in the case at hand and the facts involved in the precedent case are materially different, and what those material differences are also many times mentioned in the reported judgment. Right? Then there are many other factors which weaken the binding force of a precedent that you have to study in jurisprudence. For example, the case law that is against you may be per incurium, means it is delivered in ignorance of a particular provision. And if that particular provision would have been taken into consideration, the case law would have been different, not against you. So that is one circumstance, being per incurium. It weakens the binding force of a precedent. Now there are many other factors which weaken the binding force of a precedent, like sub silentio. Now what is that? So you have to be well versed with understanding the ratio decidendi of a case, the obiter dicta part of the case, the technique of distinction, the doctrine of stare decisis, the doctrine of precedent. Only then you will be in a position to really come to a conclusion whether a particular case law involves similar facts as are involved in your case. Now, your next question is, how many legal search engines are there? Now, you see, I don't think there are search engines categorized legal search engines or non legal search engines. A search engine is a search engine. But the famous one, which contains various case laws, is Indian Qanun. It comes in handy in difficult times. It's good resource. There may be many other sites of which I am not really very much aware. And the basic source is Google. Google also gives you some case laws, especially at least the famous ones. So search engines, I am not really. Then there is some case mine, and then see EBC itself runs their own search database on online paid version. Now Live Law is a good resource. I am naming them not because they have given me something, but these names have come to my mind. Now many journals have their online search engines, famous journals. It's not difficult to find out. Then your next question is, do we need to read all EBC and All India Reporter books? No, you need not. You need to read only the relevant portion in the books. Why from beginning to end? Absolutely no need to read. Whenever you were in law college, it was expected of you to read the prescribed textbooks. And even today, if need be, you should read the entire book. At least you should scan the book, the contents of the book. But the details, you can be choosy. After you become a professional, your search becomes laser focused on a particular topic. You don't read everything. You need not. But you need to go in depth about a particular provision. You need not go wide, but deeper. Of course, if the circumstances of your case are such that you need to go wider, then you should. You should read a larger portion of it. You should read other connected laws also, other connected books also. Many times, many cases involve such facts, the law applicable to which is interspersed in many books. There are many laws networked together which are applicable to a particular set of facts. So you need to read those other books also. So I hope I have answered most of your questions, and no answer is perfect. If you want to know more about this, then you should speak to your seniors wherever you are practicing, or you should be in the library finding out on your own. Self-help is the best help. That's how one keeps growing. So wish you all the best, and thanks for watching this video.